Hello once again and welcome to the Global Students Introduction to the Law of the United States. I am Professor Pedro A. Malavet of the Levin College of Law. Continuing our discussion of the Constitution of the United States, today I will talk about federalism. Federalism is shared sovereign authority, shared sovereignty. In the United States, we speak of one nation and the states. This is labeled as vertical federalism, the relationship between the national government, the federal government of the United States, and the 50 states and 6 territorial possessions to a lesser extent. Then there is state-to-state federalism, meaning that the states have to have some relationship with each other, particularly in a country that is as large as ours, but in which mobility is quite easy. The important idea here, however, is that most legal authority in the United States is shared, meaning that the legal authority of our governments is concurrent. And that means that sovereignty is generally shared, subject to what we call the power of preemption, meaning that there are occasions when conflicts require that the federal laws displace or preempt the laws of the states. This concurrent authority, as I presented here in graphic form, the fact of the matter is that the legal authority of the United States, the lawmaking authority of the United States, is generally shared by the United States government and by each of the state governments. And there are relatively few areas that exclusively belong to the federal government on the one hand or to the state government on the other. The concept of federalism at the vertical level, the nation and the states. Basically, the United States has 2 levels of government, the federal government of our central national government and the government of the several states. And it is really legal systems of the United States, not just one national legal system. And so you have the one national federal government, the 50 states, and as I mentioned as well, 6 territorial possessions. The concept of federalism means that there are within each state territory independent federal and state executive, independent federal and state legislatures, independent federal and state judiciaries. Now, of course, the national legislature sits in Washington, but it has authority over all of the United States. The president sits in Washington. He has authority over all of the United States. And the federal courts are found in every one of the states. And that means that there are parallel systems of government, federal and state, within each territory. Compare that to, say, France, which is a highly centralized country, where the regions into which France is divided really have to respond to the authority of the national government in Paris. That's not what we have. We have sovereign states. But our states are not as powerful as the German regions or German landers, because in Germany you have a unified governmental system within each lander. In the United States, you have these parallel systems where the federal executive agencies are operating in each state, where the federal judiciary is operating in each state. And at the same time, each state has its own governmental structures operating within the state territory. One important characteristic of the American state is that most local officials are elected. Unlike the executive branch in the national government, for example, the president and the vice president are the only top executive officials. Everybody else gets appointed by the president, subject to the advice and consent of the Senate. It doesn't work that way at the state level, generally speaking. Many state government officials, not just the governor, who's generally the chief executive of each state, is subject to election. And indeed, it's very important to note that most judges at the state level are elected officials. Contrast that to the Article 3 judge, who is appointed into his or her job and has a lifetime appointment. In contrast, most state judges are elected, and I will discuss that in my series on the structure of the American courts. But election of local officials has an important effect on federalism, of course, and in particular, the vertical type of federalism, how each state relates to the national government. But it's also important in the horizontal relationship between each one of the 50 states. To put it in graphic terms, vertical federalism simply means that we have one national government which has to relate to all of the 50 states. As to horizontal federalism, it means that each state within its own territory is independent, has independent legal authority, certainly independent of every other state, and that each state is entitled to equal power, at least within their territory, and that they are to be in a legal balance, shall we say. But, of course, there are sometimes extraterritorial laws. Let's say, for example, that a citizen of Alaska gets into an accident in Florida while visiting Disney, for example. How do we resolve the question of choice of law? Should we apply the laws of Alaska or should we apply the laws of Florida? Or another classic example, somebody fires a weapon or pollutes a river in one jurisdiction, but the bullet or the pollution end up in another jurisdiction. How do we deal with that? It is those conflicts that implicate horizontal federalism a lot of the time. The concept of state sovereignty, however, is fundamental to the American Constitution. When these 13 colonies declared themselves independent from the British, they declared themselves independent sovereign nations. There was not just one United States. There were 13 independent states that were now nations with sovereign legal power. That sovereignty, that lawmaking authority, that positive lawmaking authority that is implicated by the power of sovereignty, was then surrendered partially and voluntarily to the national government in the Constitution, and in some ways to each other, because there has to be a relationship between all the members of what is today the United States. This is, of course, internally significant to lawmaking in the United States and to the application of laws in the United States. Internationally, it is in fact the national laws that are most important. However, if you are a citizen of a country other than the United States and you're doing business, say here in the state of Florida, you actually have to be concerned not only about the laws of the United States, you also have to be concerned about complying with the laws of the state of Florida. The states and the Constitution. As I said, the states had the sovereign authority to issue law and to enforce law within their territory. And generally speaking, that means that they retain the inherent positive authority to legislate and to enforce law within their territory in the United States. The inherent authority means that there is no need for that to be expressly included in the Constitution. They had that power to begin with, and they did not give it to the national government in the Constitution. Moreover, the 10th Amendment to the Constitution expressly reserves to the right any power not expressly delegated to the federal government. And remember that the federal government is a government of limited powers. In terms of vertical federalism and the exercise of the concurrent authority that the United States government and the governments of the states have. Basically, what you have is federal and state lawmaking, and that as long as they are not mutually exclusive, they can occupy the same field. James Madison, one of our founding fathers, actually thought that it would be better to say that lawmaking by the states and by the federal government had to be mutually exclusive. But that is not what is enshrined in the Constitution. It is the shared authority that is enshrined in the Constitution. It is the concurrent authority that is enshrined in the Constitution. And so you have overlapping sovereigns exercising legislative, lawmaking, and law enforcement authority within the territory of each state. There are some exceptions to this concurrency rule, and it is preemption. It means that there's legislative exclusivity, that only one lawmaking power can exist in certain areas. Typically, we refer to this as the federal government occupies this field and must displace state law. The authority can be express or implied. Express statutory preemption means that it has been included in the legislation itself. Legislation passed by the United States Congress expressly says that this field will be occupied by federal law and that state law will be held to be incompatible if it tries to legislate in the same area. The extent of this preemption is generally a matter of statutory interpretation, not constitutional interpretation, because it is, after all, defined by the statute itself. And then there is implied preemption. Implied preemption is federal law displacing state law without express language to that effect in any piece of legislation. And there are basically two types when there is a direct conflict between state and federal law, or the state law is an obstacle to accomplishing the federal goals, but the federal legislation did not expressly occupy the field. The second one is the federal law occupies the field without saying that they completely intend to occupy the field. And these are questions for the courts. These are matters of judicial interpretation and judicial enforcement. Generally speaking, because vertical federalism does give inherent authority to the states to legislate, preemption ought to be avoided. In fact, again, the principle of concurrency is really the principle that should generally prevail, and therefore preemption can only be an exception. And furthermore, it should generally be avoided. Conflicts should be avoided. And that means that there is a legal presumption, which is generally applied by the courts, against preemption. If the matter is unclear, the court will be, generally speaking, it's the courts that resolve these problems. The court will be asked, was Congress intending that this would be the only standard to occupy the field, meaning that the federal legislation passed by the United States Congress should be the only standard to be applied in that legal field? Or rather, whether or not the Congress wanted a minimum standard which the states could in fact supplement and go above. The other question that is often asked by the courts is state legislation in a particular area an obstacle to implementing Congress's full objective? And obviously, these are difficult questions to answer, which is why they are resolved by the courts. Horizontal federalism, the legal relationship between the several states. The most important expression of that is included in the Constitution itself is in Article 4, the full faith and credit clause. It requires that states give full faith and credit to the judicial proceedings, records, and public acts of other states. What does that mean? Well, as to public records, it simply means that the records of one state must be acknowledged, must be given legal significance and legal recognition by other states. So that if you were born in Florida and you have a Florida birth certificate, that should be recognized if you move to Arizona. A marriage license also. If you are married in California and move to Florida, your marriage has to be recognized by the state of Florida as well. Another expression of full faith and credit, of course, is as to judicial decisions. And what that means is that the decisions of a state court in one state must be enforced by state courts in other states. You might wonder why that is. Well, the reason is that you may have a judgment against someone from one state, but their assets may be located in another state. So therefore, execution of that judgment necessarily requires the cooperation of another sovereign court. And the full faith and credit clause requires that the second state give the same effect to the judicial decision of the first state as the first state would give it. And that means that the second state is not allowed to say that the judgment is in error or that it is based on a law that violates the public policy of the second state. They simply must enforce it. The only exception is lack of personal jurisdiction, meaning that the first court did not have the legal authority to order the individual party against whom the order was issued to do anything. And the reason for that is the due process clause of the Constitution of the United States, which entitles people in judicial processes to be judged by courts that do in fact have personal jurisdiction over them. And I will also discuss that in my series on the judicial structure of the United States. State sovereign immunity. This is another example of horizontal federalism and also sometimes of vertical federalism. The fact is that U.S. states cannot be sued without their consent. That's the basic rule. But early on, the Supreme Court of the United States in 1791 in Chisholm versus Georgia ruled that Article 3 in fact abolished that. So that meant that states could in fact be sued in the federal courts. The response by the legislature was very quick, and by the states was very quick. The 11th Amendment was passed and ratified, and in fact that returned us to sovereign immunity, meaning that states cannot be sued without their consent. It's important to note that the legislature cannot overrule just any decision by the Supreme Court, although I think it's important to note that if the Supreme Court interprets a statute in a particular way and the legislature disagrees, they can amend the statute. But this was a constitutional interpretation. This was Article 3 eliminates sovereign immunity. So it required a constitutional amendment for the legislature and the states to overrule the decision by the Supreme Court, but that is precisely what they did. State sovereign immunity, interestingly, survives to this day even after the Civil War. There were a series of amendments that were passed after the Civil War expressly to impose constitutional limitations on the states, but that did not extend to eliminating the power of the right of sovereign immunity. There are some exceptions, however, that basically allow federal lawsuits in particular to be filed against the states. One of them is that if a government official acts in a way that is arguably a violation of the Constitution, he or she is deemed to be acting in an ultra-virus way, meaning that they're acting beyond their legal authority and therefore they are stripped of their protection of sovereign immunity. However, the sovereign immunity rule means that monetary damages are not awardable against the state in a judicial proceeding unless the state consents to suit, and that has to be done, generally speaking, expressly in a statute. Another important provision in Article 4 is the Republican form of government provision. The United States shall guarantee to every state in the Union a Republican form of government. However, early on, the Supreme Court ruled that this was a political question, meaning that it was not for the judiciary to decide that. So this is very much different from, say, the eternity clause in the German Constitution, which allows the German Constitutional Court to invalidate even constitutional amendments that are contrary to the basic principles of the modern German Republic. The Supreme Court of the United States decided that it did not wish to be involved, or that it did not wish any federal court to be involved in making those judgments. However, the Supreme Court does use other provisions to invalidate state actions that implicate the Republican form of government, particularly when it comes to voting rights. In conclusion, let me say that federalism is an important constitutional concept, but that it is adaptable, and we have needed it to be adaptable throughout our history. It is a balancing. It is a balancing of the sovereign authority of the national government and a balancing of the sovereign authority of the states and the territorial possessions. In my next series, I will discuss a moment of conflict that required an expansion of federal authority at the expense of the authority of the states.